We begin this morning with the dramatic verdict in the Kyle Rittenhouse trial, a case that inflamed debates in this country about race, guns, and vigilantism. The jury finding Rittenhouse acted in lawful self-defense when he fatally shot two men and wounded a third during the turbulent racial justice protests in Kenosha, Wisconsin last year. The victims' families expressed outrage at the criminal justice system as Rittenhouse applauded the verdict.
The jury reached the correct verdict. Self-defense is not illegal. It's been a rough journey, but we made it through it.
And here to analyze the fallout is our ABC team following the case since the beginning. Senior national correspondent Terry Moran, just back from Kenosha, chief national correspondent and Nightline co-anchor Byron Pitts, and ABC News contributor Shauna Lloyd, a managing partner of the Cochran law firm. Welcome to you all. And Terry, I want to start with you. You were in Kenosha covering the trial. Give us a sense of what it was like there, watching that tearful testimony, watching the jury, and those questions the jury asked about seeing the video again.
That tearful testimony. Kyle Rittenhouse won this case on the witness stand, and he was superbly prepared by his defense lawyer, Mark Richards. The defense staged two mock trials with mock juries before the trial, one where Kyle Rittenhouse did testify, one where he didn't. The answer was clear. And so that questioning was structured to right at the Wisconsin law of self-defense. The defense barely mentioned the Second Amendment in this case. This was not a crusade. This was trying to get the jury to focus, and they did. I watched them. There were no dawdling, no nodding off. They were very focused, and what the defense gave them was not a political case, but a case under Wisconsin's law of self-defense, and that's what they asked for during jury deliberations. First thing, please give each of us a copy of the law of self-defense, and then they went through that video evidence, knowing a lot of evidence that a lot of people around the country don't know. There were a lot of guns going off that night, and they came to this conclusion. It was not a crusade in that courtroom. It was a trial.
And Terry, on that note of self-defense, I want to go to you, Shauna. This has caused outrage for some, vindication for others. But legally, when you look at this, given the way the laws are written, once Kyle Rittenhouse said self-defense, it was a very tough case for the prosecution.
Absolutely, because once he established self-defense, it takes out a lot of the other things that people would want to argue should have affected this case. The fact that he even had a gun in the first place, the fact that he was only 17, none of those things matter when it comes to self-defense. What we're looking at is what he felt like in the moments in which he had to take that sort of deadly action. So we're only looking at the situation he was in, what someone else was doing to him, and how he felt, and whether or not he needed to resort to deadly force. And that's what self-defense is about.
And Byron, in this trial, all involved in the case were white. Rittenhouse, the men who died, but this case intensified the debate over racial justice and the legal system itself.
Martha, it's absolutely true. And for many people, it's not a debate, it's a cold, hard reality that in America, there's one justice system if you're white and wealthy, there's another if you're poor and a person of color. Study after study shows that black men are arrested more often, convicted more often, and sentenced to longer sentences than white men accused of the same crime. And the same holds true in discipline in schools, that disparity. And Martha, here's a study I think that speaks to this case and the concerns about this case. According to the FBI, a fatal shooting where the shooter is white and the victim is black, 3 times more likely that's ruled to be justifiable if both parties were white. And so I think for most reasonable people, and most surveys would bear this out, that few people, reasonable people, would believe that if a 17-year-old black boy with an AR-15 showed up in Kenosha, Wisconsin at night, killed 2 people and injured a third, that black boy would have been treated the same way by police or by the legal justice system.
And so, Shauna, I want you to look at this in a larger sense and where the laws are now. And given what Byron said as well, Wisconsin doesn't have that so-called stand your ground statute, but their laws really are just short of that.
Absolutely. And I think what Byron said is absolutely correct, because that is the larger focus that people are looking at this trial in, is that had Rittenhouse been African-American young man, would the sentence or would the verdict have been the same? Statistically, what we find is that it would not be. And so that is the injustice that people are looking at this verdict in. It's not necessarily just about Rittenhouse. It's about the larger picture of the criminal justice system and how it disproportionately affects Black and brown individuals when they are on the other side of that.
And Terry, let's go back to guns in terms of open carry and the prevalence of gun. The judge, Bruce Schroeder, he dismissed those misdemeanor weapons charges against Kyle Rittenhouse, carrying a military-style weapon, 17 years old. What does that mean?
Well, on the surface, that was unlawful under Wisconsin law because minors are not allowed to carry deadly weapons. But the defense once again zeroed in. It's a badly written law because there's an exception. There's a part of the law that says if you're a minor, you're allowed to carry a long gun, as long as you're not carrying a short-barreled, sawed-off shotgun. And they seized on that. And the problem with what the judge did is not that he ruled for the defendant, saying that the defendants should not suffer because the legislature can't tell them what the law is in this badly written law. It's when he did it. The defense had asked twice for this charge to be tossed earlier in the case, and had he done so, the prosecution could have appealed. But this was a judge who I think wanted to keep control of this case. He did not want any appeals court looking over his shoulder during the middle of the case. And so that was a real problem. Once again, though, there were a lot of guns on that street, a lot of them going off. And it was a very chaotic situation.
And Byron, I want you to pick up on that. This was in the middle of a protest.
Oh, absolutely. And that certainly complicates this case. It makes it very different, say, from the Arbery case that's going on in South Georgia. I think, Martha, for the average parent, none of us wants to see our child, no matter their age, to be gunned down and killed in the streets of America. And so that's what's so complicated, what's so disturbing, I think, for many people about this case. Certainly there's the constitutional right to bear arms. But again, few reasonable people think it's okay for a 17-year-old civilian, a boy, to walk into a space with an AR-15 and create an environment where someone loses their life.
And Shauna, I want you to address the Ahmaud Arbery case in Georgia, a major case. They are claiming self-defense as well, even though they were chasing the man who was shot.
Absolutely. And I think that the comparison in the two, you can start to see the differences, right? In this particular case, they chased him with vehicles. They approached him with weapons. And because he did not respond to them in a manner that they thought was acceptable, they continued this chase. Then he himself right now, currently in that court case, they are using and vilifying Mr. Arbery. They're using words like he appeared angry, suspicious. He was walking at too fast of or running at too fast of a pace. This is where we see the disparity in the fact that he's an African-American male and he's using these sort of adjectives to be described, and the initial action and interaction between them was created by the McMichaels and by Mr. Bryant in chasing him, even though he had no ill words to say to them, even though he did not display any aggressive manner. And I think that's the disparity that we're talking about. And when we look at the Rittenhouse case, even the judge in that case, the way he handled the defendant, the way he handled the case was very defense friendly. And I think that's specific to that particular defendant. He's someone who seems familiar to them. He seems like a brother, a son. They identify a little bit differently with having Mr. Rittenhouse on the stand. So I think that affects the trial overall.
Okay, thanks to all of you. That's a case we will certainly be watching. Thanks, Terry.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.